We'll go ahead and call Marshall County Fiscal Court to order. It's a special call meeting, June 1st, 2021. We are going to convene recess, and we're going to run over to Trigg County for a meeting. And we're going just to hear what Senator Paul has to say about LBL in that discussion. So once we're done there, we'll come back and pick up where we left off. Any questions? Just need a motion to recess. To head to
Second.
all those in favor say aye. Aye. Any opposed? Motion carries. All right. We'll go ahead and start with the agenda. I know we recessed, but we've got Elena Blevins to give us her budget.
Yeah.
Thank you.
Thank you. Good afternoon. It's that time of year where I come give my best educated guess on what we can expect to see. So I emailed the budget to everyone last week. This is our proposed 21-22 fiscal year budget. The Board of Directors has approved it. Going through it, as far as income goes, we are actually estimating to have a rollover of about $100,000. Essentially, we ended up doing okay. We did not see the negative impact as much as some of our other cities, metropolitan areas across the state did. Honestly, when summer hit, we ended up being a very safe destination for people to come and visit at Kentucky Lake, and they rented out homes and cabins and cottages all along our resorts, and we did okay. So we had a great summer. We weren't quite sure what to expect going into fall and winter, if there was going to be a second wave, if we were going to be facing another shutdown. And I will preface and say that a lot of our resorts did shut down in the spring. So that March, April, May time period, several resorts made the choice to shut down, cancel their visitors, reservations, and we really kind of did not know. So we actually shut the office down at that point in time. I worked from home for those months. We canceled or paused all advertising during the spring of 2020. But then, like I said, summer hit, we ended up doing fine. But when we went into the 1920 fiscal year, we took cues from most of my other colleagues and co-workers across the state. Everyone was cutting their budgets by about 50% to 25%. So we chose to do the same, take the really conservative route. So we cut the budget by 50% with the exception of this last quarter that we're in now, and we only cut it by 25%. But we exceeded our expectations every month. So now I will preface once again and say that we're not where we were. Our best years on record were fiscal year 15-16, 16-17, and 17-18. During those years, we ended up doing about $350,000 in transient room tax. So if we stay on track to where we're at this year, and we end up getting what we kind of estimate will be at $265, about, give or take. So we're still not back to where we were pre-pandemic and pre-Asian carp crisis. So we still were facing a budget issues because of the fishery, and trying to figure out what to do with that. And then the pandemic happened, and so. But I feel like we're actually coming out of it all. We're starting to see signs that the fishery is returning. We're having really good conversations, and I think within the next couple of years, the fishery will be maybe not back to where it was in our heyday, but we'll certainly be able to start going after those large-scale tournaments once again. So we're looking forward to that. But so going into this fiscal year, we are projecting about $100,000 rollover. We're estimating $300,000 in room tax, local transient room tax, and then we have about $45,000 projected in other types of income. We sell ad spots in our travel guide. We have the travel marketing incentive program through the state, which allows us to apply for reimbursement, a portion of reimbursement for marketing and advertising costs, as well as rental income, which is a new source of income for us, because I hope everyone is aware now, the Chamber has moved into the tourism office. So that has also provided a new source of income for us. And so far, it's worked out really well, us being in the same building. sort of a one-stop shop for our local business community and our tourism industry, and I really hope that it's going to lead to some really great partnerships and projects in the future. We were also able to, finally, we did not qualify during the first round of PPP just because of the way we're set up, but we were able to get language added into the second round of PPP that allowed for CVBs, DMOs, quasi-governmental branches of the fiscal court like us to apply for a PPP, so we were able to get that, and that has helped alleviate any pressure off of payroll costs. So you'll see in our expenses there, we do have that liability listed. We have our building expenses, administrative needs, advertising and marketing, advertising support, of course, and then payroll. And then this is the first year we've actually operated with a small reserve fund. Obviously, with the budget crisis that happened because of the fishery and then the pandemic, we learned firsthand how important it was to have at least a little bit set aside so that we could operate. So because in the past, we usually always had to take out a line of credit and try to get things. I mean, Erica can attest, I would like email and say, do you have any money to transfer, prior to this? So it's really nice to be able to set that aside and have that. Payroll that includes my full-time position and then a part-time position as well. We were able to hire a part-time social media content manager. So you have breakdown percentages there. You see administrative is about 20%. I'm really excited that 46, nearly half of our budget is actually going to marketing and advertising, which is why we exist. I think we're going to be able to do some really exciting and aggressive marketing campaigns this upcoming fiscal year. Hopefully have some new events and new things that we can try to recruit to the area, just because we've been able to do such a robust marketing and advertising line item. And then, of course, you have payroll at 22%, and then our reserve fund and our PPP liability each at about 5%, a little over 5%. So it's really about all I got, unless you guys have any questions for me.
How's the, I know we did a ordinance with the Airbnb type businesses. How's that?
I actually just looked those up because I figured that was going to be asked. We actually bought a platform called AirDNA, and this is a company that tracks active rentals. And then it allows me, I can go on AirDNA, and I don't know how it does it, but it tracks a property that's listed on Airbnb, VRBO, and whether or not how long it's been rented throughout the year, what the average nightly rate is, and it gives me all this information. And then I was able to go to the PBA's office and have an account set up with them. And then I went to Jason, and we were able to come up with a letter that I could submit. So it's very time-consuming, and I have to really kind of set aside a full day to go through. I've managed to go through the zip code of Gilbertsville. I think we sent out about 25 letters to private home rentals that I could verify that they were renting on AirDNA, and found out who they were through the PBA, and then were able to contact them. So, but according to AirDNA, we have 56 active rentals with a Benton zip code. We have 62 active rentals in Gilbertsville. We have 14 in Hardin, and then there was about 6 in Calvert City. So you're looking at about 140 private homes. I'd like to say I have the majority of those signed up.
Yeah.
I don't think I do.
Yeah.
But like I said, it's a very time-consuming process to verify the property owners, get the letters, and send out to them. But we're getting there. We definitely have more signed up and registered now, and actually submitting the tax now than ever before. So that's good. We're making progress.
Does it give them like a time frame, I guess, to
Yes, I believe it gives them
contact you?
60 days to register with the county through the ordinance that was set there. They register, and then we have now that the file and the return are actually on the county's website. We just tell them to go there, print off 12 copies, and just be prepared to submit one every month.
Yeah.
So we're making progress.
Good.
Good.
Erica does Elena, I'm sorry. Elena does the hard work, and then we just
Put it on letterhead.
Oh, the
on
letter.
there, so.
Put your name on it, and it scares people.
Which I said my intent was to not scare people, but I had tried submitting a letter to folks that I found on my letterhead, and it did not yield the return I had hoped. So I needed something a little bit more official. I have had a couple of phone calls where people have been like, but I've just explained, we're just trying to get people's attention. It's not fair that you're operating.
Right. It's only
and
fair.
You're not paying when other people are,
Yep.
and so it's really, we're not trying to get you in trouble. We're just trying to inform you
Yeah.
that there is something that you need to be doing.
It's not fair competition to those that are
Yep.
doing it. And, I mean, we all know when you go out of town and you stay at a hotel or something, I mean, they're just passing that on to the folks. It's not a huge
Yeah, it's a
amount of
consumer
money.
tax, so yeah.
It's a consumer tax for sure.
Well, we are a tourism community, and
And that became
That's-
very evident
yeah.
this past year. I don't think I will ever take for granted Kentucky Lake. It saved us, honestly.
yeah. Well, all right. Has anybody got any other questions?
I love seeing you guys work together too.
Oh,
The
thank you.
chamber, I think it's awesome that they're in
Yeah,
there. I wish we
Mitchell
would have had that when I was involved in the chamber. Honestly, it would have helped out.
I
a
think
lot.
it's going to be a really good path forward.
Mm-hmm. Yeah.
We need a
I move we approve it.
second. All those in favor say aye. Aye. Any opposed? Motion carries. Thank you, ma'am.
Thank you.
Thanks.
No correspondence, old business. Approve the minutes, May 18th meeting.
Second.
All those in favor say aye.
Aye.
Aye. Any opposed? Motion carries. Old business under B, update sheriff's office retirement. I think the court got an email from the county attorney's office regarding this. We did get communications from the state retirement agency. They're now KPPA. They changed their name from KRS to KPPA. And I had Dez do some math because they identified and accepted some, but they didn't others. And it's about $365,000. But I think the issue, you kind of, counsel, you kind of brought some things to light as far as a KAR. We had a similar situation with a KAR and 911, the user agreement, which is actually in their KAR. And if you guys remember, the user agreement has been changed at least 7 times, 6 or 7 times since we've been looking into this for the past 2 or 3 years. And how it kind of ties in with this issue is some of the required documents from the state agency regarding the retirement. Those are not listed in the KAR. And so my question to the court is that, you've read what the email was sent out by counsel as far as appealing the state agency, but I think it sheds even more light on another state agency that actually has a KAR, and the issue that we brought up or we discussed was they never changed their KAR. I mean, I'm sure you guys know, when you change a KAR, you have to have a public hearing. I get quite a few from the labor cabinet that I send to Brad, and Brad sits in meetings, and they have public hearings, and there's a whole host of things that have to be done when it comes to any changes to the KAR, which is good because the KARs are guidance, if you will, for government agencies. But if you remember, the court, we put an ordinance in place. It was a unanimous decision. The entire court stood behind that ordinance, and the state agency didn't acknowledge it. I think their response to us was that there was already an ORI that the agency had, the local agency had, and there was no discussion as far as trying to appeal. I know you went on vacation. I know I was on vacation when we were dealing with that. Brad, you and Chris were constantly getting correspondence from the state agency as far as the user agreement. And we went through that whole process, but there was no recommendation to appeal and potentially litigate. And I think these two issues have similarities that we should look at, because we still, as we sit here today, we have a state agency, which happens to be KSP, that basically didn't acknowledge what the action of the court, what we took. And personally, I think that, we should have appealed that, if not anything, litigated, because there's no language, there's nothing, it's never been, I guess, litigated, from what I'm being told in the state pertaining to that issue. And I think that this might be similar when it comes to the KPPA, as far as those documents that they're saying that are required that are not in there. So I just want to bring that to the court's attention as we move forward with this issue, that there's a lot of similarities with those two issues. Is there any discussion?
I'm just trying to, what are you, are you saying that you feel like that our appeal will go unheard because of
No.
What the KSP situation, or?
No, I'm stating that there are a lot of similarities in what council had pushed out to the fiscal court members as far as documents not being in a KAR. And we have a similar situation where a KAR actually has a user agreement in the KAR. Clearly, it has to get an answer. I mean, you can get an answer from the AG's office, but it's just an opinion. But those issues typically end up in litigation. And that, to me, should have been what the court should have done, is appealed that state agency's opinion, which was they didn't recognize it. And we're talking about an ordinance set by this governing body for the county under another statute that clearly gives us the authority to put ordinances in place. And then there's other state statutes that require, a KAR. If there's a change, you have to have a public hearing, you have to make a public announcement. I mean, we've gone as far as open records requests to the Public Safety Cabinet and asked if there were any correspondence put out regarding changes to a KAR. And they had none, particularly to that KAR. And, the similarities are the same. But the difference is that this governing body put an ordinance in place, and the state agency didn't acknowledge it. And that's another issue that I think is important. So there's definitely discussion here, because all of us were on that email thread as far as what council's interpretation was. And it's no different than, and Jason and I, we sat down with the previous issue and discussed it. So there are some similarities here. I don't know why some went to the media on the last one. That's another issue that I think we need to discuss. But yet, this is, when we're talking about potential litigation, or if we're talking about appealing to an agency, we should be consistent. I mean, obviously, this issue is several $100,000. And there hasn't been, I don't think, that much communication, if it wasn't for my staff finding those issues, there hasn't been much communication as far as the issue at hand compared to the previous issue with 911 and the user agreement. I mean, there was a lot of time spent, not just with my staff, but with myself, sitting across the table from those or that particular state agency, and other state agencies. And, they changed the language that we pretty much sat down with them and said, you can't do this. They changed the language, but they didn't change their opinion. They still don't recognize our county ordinance that this governing body put in place. And, I just asked the question, why haven't we appealed, or why haven't we litigated? Because that's pretty much the advice that was given to me from another agency, as far as attorneys, saying, hey, it's just not been challenged. There's no, the courts haven't looked into this because this is new. And I asked that question.
I think as far as this goes, that I don't think there's any question we need to appeal it, for sure. I mean, it's my opinion on this issue with the issue at hand, for sure.
Sure, that's an option. But do we appeal the other issue?
Jason, did we ever get an official response from the email that we sent? I haven't gotten any correspondence since the email you sent that day.
We're
Did they
supposed to get a
respond?
final determination letter that says, that outlines the appeal process.
But we haven't.
I haven't. I didn't get it in the email today.
Yeah, I haven't either.
So you're talking about an official response has been sent for an
That's-
appeal?
My last email to them was, when are we going to get our final determination letter? Because the reg requires them to send a final determination letter that outlines the appeal process.
If it's the same email that I saw, they couldn't produce that until information's, I think they said under section C and D, was provided. Once that was provided, they did send their opinion, which I'm assuming is their response to your letter. I think they even stated that they cannot answer your question until they get that information, because they don't have it.
I've gotten,
No, that
I've
was-
gotten
that was
correspondence
before.
between them.
Yeah, that
since
was
then.
before.
And
This Dewan Surratt was the one who sent the last email to me and said that for certain officers, they were going to retro it, for certain they weren't, and he mentioned these required documents. And my reply to him was, when are you going to send the final determination that includes that it outlines the appeal process? And I don't think they've sent that.
No, and that's because they need the pay stubs.
No, that was given to them. I think that
No,
was,
I
I think that
talked
was
to
given.
Des, and she was asking as far as the pay stubs. The email, the one, I think is his name, basically said that as far as identifying who falls into that category, there were several that didn't fall into that category, and then there were since some others added because they have come and gone. But to get from them, she was saying that they need the actual pay stubs, like when they started, how much they were paid, the health insurance. I mean, there's a whole list of information that each one, as you can imagine, is different than the other, and that information has to be submitted. And then the way she understood it was that then they would send a bill, I guess.
They've already made up their mind that it's owed, so that's the appealable issue, not the amount.
Not the amount, right?
Yeah. Well, yeah, if the issue to appeal is that they don't retrograde. But as far as, if I understood, May 1st, all the documentation that was required by the state agency was met on the individuals and submitted. So starting May 1st, they are, as far as administratively, are accounted for. It's everything prior to May 1st that they don't, that's the information that they're trying to get before they can send an invoice to us. So in a way, it does tie in. The appeal is that the retrograde, they won't retrograde. And I get that. I mean, as far as your email, it even talks about those documents not being in the KAR. But I don't think that we can, until they get the information that they're looking for, that we apparently have to give them, we won't have a final slap on the table as far as, I mean, this is a calculation that she has done, Des has done in-house, but she has since sent that information to them pertaining to 3 individuals who are no longer with us, and they fall into that category as well. Last week, maybe? And that's because, if we're going to look at the totality of everything, to have them review, put it on the review, even those that are no longer employed, but they were during that time frame that they're saying, the documentation wasn't submitted, they still fall under that. And that was their latest response, was that those 3 do fall under the same jurisdiction of not being, I guess, for lack of better terms, no retirement being paid while they were employed during that time frame.
I didn't ever know that.
Do what?
I wasn't aware of any of that back and forth. I haven't heard of anything since we were in your office and sent the reply.
I'd say the latest correspondence was for the 3 officers that are no longer employed. They would fall under the same jurisdiction as the others. That's the latest communication. I sent correspondence to Dwayne. I haven't heard anything from him. That may be something that they do through their protocol. I don't know, but I haven't heard anything directly from him because I had questions and I left a voicemail and didn't get anything back. But
The reg requires them to send out a letter saying that this is their determination, and this is the appeal process if you want to invoke it.
And I think they are still requiring some more information, the way I understood it, before they can send out that letter. I know they're doing the emails back and forth because of the confidentiality of it, the nature of it, but and then you get into, you're talking about a state agency and 2 employers. So I can get with Des to find out exactly, and I don't have a problem telling her to go ahead and submit whatever it is they want to make that happen. But I think the issue is that they are saying that this amount is owed indirectly. And if the statute says that they have to directly send that letter, I think it's inbound, it's going to be coming. That's why we're discussing this.
So the last sentence of that email, I see what you're referencing. What you're saying is no one has sent that information back to DeWan, right? The payroll records for those 1, 2, 3, 4, 5, 6 guys, I think, from the date they returned back to employment through April the 30th. That's what you're talking about? They would need that before they can respond with an amount.
Yeah, because if they want to make an official letter, they're going to need the official information, for lack of better terms. You have to go back and you have to remember they had none of these individuals in their system, so they have to get all the information, I guess, before they can actually send something like that. I don't know, I'm just, that's why I wanted to talk to DeWan. I didn't get to talk to him, but that's the way Des interprets it as well, that they need that information. While they're looking at that, the similarities on this, and you guys read council's email, the last issue that, and I do have an issue with this, because the same issue with the KAR has the user agreement in the KAR. I think it was 1986, don't quote me on that, but it's been that long ago. There have been no changes to that KAR. If you go back to July of last year, the amount of time that I had spent on this, been about 2.5, almost 3 years, looking into this. And Kenton County, because all counties had to go through this, Kenton County wrote their correspondence. Boone County copied it. Boone County took Kenton County's name off and put Boone County on it. Well, we did the exact same thing. I had the county attorney's office sign it before, because I know Jason went out of town. I went out of town. I even reached out to David Elliott, Chief Elliott. He was going out of town. But we had already signed the user agreement. What I wanted and what I got was I got the CSO that actually wrote a letter stating that, and this is, you have to go back to the previous lack of acknowledging, and this is a state agency, which I question if they even have the authority not to recognize a county ordinance. I mean, that's one of the things that I question. This governing body put an ordinance in place. There's no statute that I can find that says that, a state agency, particularly in this case, KSP, has the authority to not recognize a county ordinance. But anyways, the CSO, and the CSO is the senior point of contact for CGIS with the FBI for the state of Kentucky, wrote a letter to us. And later that week, Brad had been in correspondence with some of the state employees, and I believe they called the sheriff and they called the chief in Calvert City, and these are state employees. My correspondence has been and had been with the CSO the entire time, but they had communicated to certain individuals that CGIS was going to be compromised, that they were going to have to be getting their reporting from Post 1, all this backdoor stuff, when the elected officials in my office, the people that were involved the entire time, county attorney was involved, we all knew what was requested. But that letter from the CSO said we were the last county in the state to be in compliance with the CSO or the CGIS required documentations. Once we got that letter, we sent the language that was already approved in Kenton County and Boone County. We literally just put Marshall County on it. And Brad, I was on vacation. I told him, I said, all right, go ahead, send it. And he sent it, and it was, 23 minutes? It was denied. The reason why my office did that is because there is a difference as you move across this state and when you're dealing with state agencies. It's kind of like what we heard today, right? When you start looking at the government and the government agencies, there's a, for lack of better terms, I think today we heard incompetence, but the biggest thing is the lack of communication with these state agencies and interpretations. In this case, the CSO, nobody else, has that authority, and he put his name on that letter to our county, and we were denied. But yet other counties were approved. And if I remember correctly, they said it was a verbal commitment. But regardless, we had already had it signed. Once we got that, we sent it. We sent the county attorney's office as a criminal justice agency. We sent that to them. But that letter just proved that there are, decisions that are being made at these state agencies that should be challenged, especially at the local level. And that's what we were doing. But what we don't do, especially if it's something that is to be appealed or to litigate, we definitely don't go running to the media. And that's what happened back on August 4th. I had to contact your office to get that redacted because it had nothing to do with what my office was doing. And if it was an issue that was of a serious nature, well, then that's what we, as the elected body of this county, should be discussing. But that didn't happen. And yeah, I do raise questions as to why that didn't happen then. And if you look at the KAR, and you and I talked about that, we looked at the KAR. You agreed. The actual user agreement is in the KAR. And so that in itself can be challenged because you've got a state agency that's changing it, right? If you change a KAR, you have to have a public hearing. And as I stated earlier, I had Brad request any public hearings regarding to that KAR, and there were none. So they hadn't been changing, or they haven't been doing what technically was officially what they were supposed to be doing by having a public hearing, because if they would have had a public hearing, that was my whole argument when I went to Frankfurt. And I went to the governor's office, and I said, we need to sit down because where is our voice? We don't have one, except if you change that KAR and they have a public hearing, that's where we can go and I can sit down and I can challenge what they're changing. But we weren't given that opportunity. And so in that meeting, I had to get everybody to the table. the Public Safety Cabinet, KSP, the Governor's Office, KOHS, all these agencies to sit down at the table to say, look, you know, in essence, you're holding us back. All of us want to protect CGIS. And they changed it. They knew that that wasn't in my opinion, that was a very good argument legally, you know, because it is in the KAR. And strikingly similar, this is regarding the KAR with documents not in the KAR that this state agency, the Retirement Board, is actually citing.
Mine also has a statute, though, too, that, I don't know all the details about that, but 7292 and 293 outlines it, and it specifically says that our agency shall not pay retirement benefits or insurance benefits. Plus, we backed it up with the KAR as well. So we've got statute on our side, and we've got KAR on our side on this one. Basically, the form in question basically just reiterates that you've met statute when you hire someone back. And all of ours met statute, or they wouldn't have been approved on May the 1st, so.
And that was in the email. I'm not arguing that.
Yeah.
I'm arguing
I don't
if
know
it's
about
an
this.
issue of
I just didn't want
an
them to think it
appeal
was only a KAR.
and litigation, there is a process. And going to the media is absolutely not a process. I condone it. And I think the court should as well. This issue that I'm referring to went straight to the media. And the individuals, my office, you as elected officials, we're the ones that have to handle that issue. It's our ordinance. You know, and I do find that's my biggest complaint today, is that the same issues, we have an appeal and potential litigation with the state agency, but how it was handled. And I know why, but I don't condone it, and I won't participate in that type of behavior.
Are you saying that I went to the media?
Well,
Because that's not true.
Let me just say so I'm clear on what I'm saying. August 4th, you're quoted in the paper.
They called and asked me, were we in danger of losing our PSAP? And I said no.
Yeah. Let me be clear on
I mean,
what I'm.
if
Let me
you
be
think, if
clear.
you're, no. If you're
Let me
accusing,
be clear. No.
If you're
Counsel, let
accusing
be
me of
clear.
going to the
I'm not-
media,
No.
then that's not true.
Let
That is
me-
absolutely false.
Let me be clear on what I am saying. I'm not accusing anybody of anything.
I believe you are.
No,
You
let
just
me.
said that you quoted me from the media. You're taking that out of context.
Do you want me to read what's in the paper?
Please.
This is referring to a potential appeal and litigation. Regardless of
Read it.
your appeal, your guidance to this court as counsel should be appeal and litigate.
And we talked about that in your office.
But there was no guidance.
We talked about that in your office. We talked
Let-
about
let me-
getting an
let me
AG
be-
opinion.
let me be-
And then taking that to court.
Let me be very clear.
And then we got them to approve me as control and whatever.
No, that was my.
Whatever it's called. And then it died
It's a
down.
user
You didn't say
agreement.
anything to me further about litigation.
Okay, let's back up, because it's not you. It's the way this was handled. The sheriff and you were quoted in the paper regarding a similar situation with an appeal or potential litigation. That's what I'm talking about.
Read what I said.
I'm just going to read the entire article, so I'm not misquoted.
Okay.
And I did communicate to you, because I didn't even know about it. I had to find out by somebody else saying, have you read this? And when I called you, this wasn't printed correctly. And I directed you to contact that agency, WKMS, to redact it, in which they did. But the basis of what I'm saying is I'm not accusing you of anything. What I'm saying is that this is a potential appeal right here, or litigation. Regardless, it should have been no comment, because he's not the employer. We are the employer. This governing body is the actual employer. I had a law firm come here and lay that out very clearly. We are not the employer. He's not the employer regarding this issue. That was known. We are. This is involving a PSAP that we actually have. It's under our jurisdiction. There's an ordinance that says that. What I'm saying is that there is a huge difference in how a potential appeal and litigation was handled, and I totally disagree with it. So this is the August 4th newsletter that WKMS put out. Marsh County E91 Department is working to maintain access to the National Crime Information Center, which is NCIC. Database after a change to the department's classification sparked debate on whether 911 program is properly credited to continue using the service. Now, where is that debate?
I'm just waiting for my quote.
I know you are, but I'm asking, where is that debate? Because when you and I talked, or when I handled stuff, it was in my office or in Frankfurt. The Marsh County Fiscal Court approved an ordinance in March classifying the county's 911 dispatching center as a criminal justice agency. The ordinance explains the county's 911 telecommunicators perform tasks that more closely align with an agency involved in the administration of criminal justice. Marsh County Sheriff Eddie McGuire told WKMS the Kentucky State Police disagrees. Again, we're the employer. That comes from a phone call that he and the Calvert City chief, but the Calvert City chief chose not to get involved because he has nothing to do with that. They were contacted by state employees. Now, as I stated earlier, the CSO and myself had already communicated. You knew that. You knew that communication. You were shared with that communication. The Kentucky State Police disagrees with the county's interpretation of a criminal justice agency. Where? Where does the state police disagree with that? I've got the official correspondence from the CSO.
Is that my quote?
I'm just saying. You're quoting in this article, and you and I talked about that. I called you. McGuire said only agencies with a user agreement may access the NCIC database, which he said the 911 department does not have. The system allows law enforcement officials to search for records, including stolen vehicles, missing persons, and registered sex offenders. This is a quote. I got a call Thursday morning, July 30th, from an auditor with the state police that said 911 had until Friday, July 31st at 3:30 p.m. to sign a user agreement with the state police, McGuire said. You were aware of that. I was aware of that. That document was already signed before he went on vacation, before I went on vacation. He didn't know that. That's business that my office did with the county attorney's office. McGuire said the sheriff's office originally served as management control for the 911 department's access to NCIC. He said the new criminal justice agency designation for 911 stripped the NCIC management responsibilities away from the sheriff's office. if you remember when you and I communicated about that, because they didn't come to the actual agency, which is this board, under the ordinance that this fiscal court put in place, that is in control of the 911. They went to you, and I asked you if you knew what you were signing, and you said no, because the changes that the state agency had done put a lot of responsibility, and you should know this because now your agency has those responsibilities. And this is where it gets into where you've got a state agency changing a KAR, if we're going to argue that. But it changes the responsibilities that I know you and your agency had no clue of those changes. Place management control of the database with the county attorney. He said KSP contacted him earlier in the year, but the agency said they would wait to remove NCIC access because of the ongoing pandemic. With the looming threat of KSP physically confiscated NCIC-related files from 911 control, county leaders and the state police agreed to place management control of the database with the county attorney, Jason Darnell. Darnell is the chief legal advisor of the fiscal court, and KSP said his office qualifies as a criminal justice agency. Quote, "We have no ongoing disagreement about what a criminal justice agency is in terms of the definitions based on federal and state law, and we're still working with the state police on that," Darnell explained. That's your quote. Darnell said his office serving as management control is a temporary arrangement that will not disrupt the county's access to NCIC. He said 911 Director Chris Freeman is in steady communication with KSP, and the disagreement comes from the interpretation of statutes. Darnell has requested an opinion from Attorney General Daniel Cameron to clarify the types of organizations that qualify as criminal justice agencies. He said the Attorney General is in receipt of that request, and the county is waiting for a response. This is the correction I asked you to redact. The correction notice, the article was intentionally published on August 4th with the title Marshall County E911 Organizational Change Temporarily Jeopardized Access to Key Crime Database, and was changed on September 1 to the current title. Marshall County Attorney Jason Darnell contends the county always had a fail-safe backup plan to maintain access to the NCIC database, so there was never a danger of losing access. The title was the only change made to the article. We apologize for the error. This is the correction that I asked you to make, to have them redact. But my point is, when you read this article, it's still potential appeal and litigation. The consistency, that's what I'm upset about, is that the consistency to this court, if we're going to appeal and we're going to litigate issues, then that's what we need to do. In this case, the similarities are extremely the same. We are the employer when it comes to 911. As we laid that out, this court passed an ordinance unanimously because we are the employer. When it comes to him as the sheriff and his appointment, we are not the employer. He's the employer. And it clearly states on those documents such that he is the employer. So because that funnels through our office, it goes back to what he has been screaming all these years. If these offices are going to run through our treasurer's office and we're going to be doing the books, we have to have some type of, and we talked about this in the budget meeting, we have to have some type of control so that we can, at least try to catch some of these discrepancies. But in this case, this issue, we are not the employer. And that's when I had
think
Denton
there's
Law
some-
Firm come.
I think that's up for some discussion as well.
And that
I think when you look at the definition of employer, when it comes to KPPA,
Yep.
You are the employer, the fiscal court,
But you-
because you issue the checks.
Okay,
Fee
yes.
pool.
Okay, we talked about that, but you have to go back to who actually does the appointing. Do we do the appointing? We don't do the appointing. Before you appoint, you have to submit this paperwork to KPPA. That's the difference here. We're not the employer at that point. And where the discrepancy is, in some cases, that those papers weren't submitted. KPPA didn't even have these employees in their database. So yes, he's the employer, not us. It doesn't matter what the intent is. It doesn't matter what he submitted. That appointment power, correct? Me or none of these three have the appointment authority to hire, somebody to be a deputy. We don't have that authority. That falls with the appointing entity, just like me in my appointment to boards. They approve, I appoint. When it comes to employers, when we do employment, we hire, and the fiscal court approves. When it comes to appointing somebody, especially in law enforcement, in this case, this particular case, we don't have that appointment power. So yes, there is a distinct difference. Now, since the books are done in our office and under that umbrella as far as employment, that's going to come to us because we submit once he makes the appointment and they are approved by KPPA, then that is brought over to us so that we can properly turn in what needs to be turned in to the state. Desiree doesn't have the authority to appoint. I sent an email explaining that very clearly to the sheriff's department. The treasurer does not have the appointing authority. We can't determine what his intent is. And I'm just stating the facts, unless the proper documents are submitted to us. Because I can tell you, how many employees we have? 170 something employees. When this governing body, employer appoints and hires, DES in the treasurer's office is directed to submit to the retirement, KPPA, and they do.
If that was the case, then we wouldn't be paying retirement on anyone.
It's
How do you know
it's-
that, then why did we not pay retirement? If I didn't give you all anything to approve you all not to pay the retirement, then why didn't you? Does that not make sense? I mean, they knew they were retired deputies when I take them up there. And like I
Okay.
say, again, up
It
until
is
a month
not-
ago, I had no authority to speak to the
You
retirement
just
board.
KPPA
confirmed.
wouldn't even talk to him.
KPPA talks to whoever was in the database. The
They didn't,
KPPA
yeah.
doesn't even talk to me.
Right, treasurer's office only until a month ago.
The only way that it was found, well, you got to back
And I'm not
up,
blaming the
because
treasurer's office.
KPPA
I'm
talks to
saying
him.
Per statute, we don't have to pay it.
KPPA talks to him.
We've been rolling on this for an hour.
There's the
We don't
email
have to pay it.
communication.
Ask him if KPPA talks to him.
They do now because of this issue, and they put us on the approved list.
There's correspondence between you and KPPA. Here's the deal. The issue is, and I'm going to stand up for my staff, that's not their responsibility.
I'm not blaming them.
That's
I'm
not
just
their
telling you.
responsibility. So at
We
the end
meet
of the day,
statute, and we meet KAR, and it should be appealed. That's what's on the agenda. That's what we came here to talk about. I would appreciate it if you would consider appealing this issue.
I'll make a motion to appeal it at the appropriate time as Jason seems necessary.
I'll second the motion.
what was your motion?
To appeal before a KPPA hearing officer. Is that correct?
To appeal what? I just said,
Determination of their,
we haven't received it.
he says it at the appropriate time.
What's your motion?
To appeal this to the KPPA hearing office at the appropriate time necessary, if necessary.
There's a first and a second.
I don't think you could have the if
Okay.
in there.
When necessary.
There's a first and a second. Now, with continued discussion, because I'm still going to stand up for the employees, it's not their responsibility. It's your responsibility. Fill the proper paperwork out to bring to them. KPPA doesn't know what the intent is of local authorities. The treasurer's office doesn't know what the intent is. At the end of the day, this is an appealable issue. And yes, I'm not accusing you of anything other than if there is anything that is potentially appealed or litigated, going to the media, I will condone it every day of the week.
Condemn it, not condone it.
I'm going to
But that's neither here
condone
nor
the
there.
actions of it.
That's neither here nor there. I did not go to the media. They called me and asked me one question. Were we ever in jeopardy of losing 911? And I said no and explained why.
So you spoke to the media. Let me correct myself.
Yes.
Speaking to the media as chief counsel for this governing body, knowing that a potential, and you and I had talked,
And
I was
that did not
unaware.
jeopardize our rights in any way whatsoever.
It doesn't matter.
Yes, it does
Judge,
matter.
Jason,
It did not
yeah, it
jeopardize
matters a
us
whole
in
lot.
any way whatsoever.
You and I had
Judge.
communicated. Hang on a second. You and I had
Beating a
communicated.
dead horse here.
You and I had communicated. You never communicated to me. I called you and asked you, what is it? And it's inaccurate. We had to do a
They
correction.
didn't get that from me. I corrected them. They had it wrong to begin with.
I
I'm
asked
the one
you.
who corrected them.
I asked you to correct them.
They called me and said, are you in danger of you losing 911? And I said no. That the headline got wrote incorrectly despite of that. And I called them back and asked them at your request to correct it.
It's a simple thing, as you and I talked about it. You were fully aware of what was going on. Anytime the media talks about anything that's with a pending litigation,
And it did not
there
jeopardize
should be
us in any
communicate.
way.
It's not about
Yes, it is.
jeopardizing.
Yes,
It
it
should
is.
be everything about you communicating to me that you talked to the media. And I know where that came from. The bottom line here is that
So
this is.
I was supposed to let them run with the headline that we were going to lose, we were in jeopardy of, because that's what they were going to do, that we were in jeopardy. He asked me
That's
to.
what they did. I
I can't help
contacted
it
you.
that they put it in the paper wrong.
Well, I contacted you and told you to have it redacted, and they did. And it should
And if
never
you-
have gotten to that, especially when we're talking about potential litigation.
And as far as the other issue goes, we talked for 2 hours probably on multiple occasions about taking that issue with CJIS to litigation. And you decided, along with Chris Freeman, that we were going to ask for Attorney General's opinion.
And your response about the Attorney General's opinion is the law is the law. At the end of the day, Jason,
My response was. if-
pending litigation.
Are you gonna let me
is-
finish?
Pending litigation is always,
Okay, you're not going to let me
so-
finish, so I'm just going to keep talking. But at the end of the day, you decided, Chris Freeman decided, I decided to ask for an Attorney General's opinion, and the discussion we had was an AG's opinion in our favor would be helpful in litigation. In the meantime, they made me management and control, and that was the last I heard about any kind of litigation until today. Until you brought it up to deflect away from this other issue.
No, the issue is the fact that it's litigation, period.
Judge, he has a right to speak to the media, just like us commissioners have a right to speak to the media. The sheriff has a right to speak to the media. You have a right to speak to the media.
Yes.
He did
Amen.
nothing wrong. Nothing wrong.
This doesn't have anything to do with about a right to speak to the media. The conversations, in my opinion, when I sit down and talk to you about issues like that, what you say to the media, you can be held accountable for that. And this is accountability right here. There's reasons why, especially when it comes to pending litigation or appeals, I don't talk to the media because of that issue. I would expect the same, but apparently that's not the case. That is my chief issue. Now, when this issue comes up, clearly we are not the employer, we are not the appointing agency, and immediately appeal and litigation is communicated to the governing body. When I sat down with you on this, I showed you what my staff had, and if it wasn't for an honest sending physicals, documents,
to KPPA, this never would have been found. And it is an issue because the biggest thing in the room is the potential of $365,000 that may have to be paid. It doesn't matter if it's an appeal or if it's litigation. The losing end of this issue is the taxpayer. So yes, I am going to ask tough questions. And if you're going to the media, or if the media comes to you and talks to you about stuff that you and I have talked about, and you don't call me and tell me that you communicated to the media, and I find it out, not by you, I'm going to have a problem with it, especially when it's litigation or an appeal.
It has nothing to do with
It
the
has,
fact that it's
for me, it
litigation.
has everything to do.
It may, but it
It
doesn't
has
really have
everything
anything
to
to
do-
do with litigation.
Tim,
And
This
this
is about a side issue with the ongoing beef that you have with the sheriff. That's all this is about.
That's
And
all
you
it is.
you
Let me-
dropped the
me-
litigation on the other one.
That's all it is.
Let me
The only reason
read.
you're bringing it up today
Let me-
is you dropped it. The reason
Let
why we
me
didn't,
read
the
to
reason why we
you.
didn't litigate it is because you didn't want to. You dropped it.
It's still an
You
issue.
never brought it up with those three commissioners sitting over there, not once.
How do you know that?
We
How
never
do
talked
how do you
about it
know
in
that I didn't
executive
talk to
session.
them about it?
If you did, it was illegal.
Not in a continuation of a quorum. But how do you know that I didn't talk to one of them about it?
Did he?
$365,000 is what's the issue here today. And yes.
That is what the issue is. Now,
Yes,
it's been
it is.
sidetracked about half a
Yeah,
dozen
an
times.
hour
But
later,
that is
now
what
we
the
know.
issue is.
Well, at the end of the day, in my opinion, if there's going to be discussions, especially between me and you, and we've had these discussions, I've sat down with you and told you, and if there's issues, especially this, I sat down with you, and I laid everything in front of you and told you, here it is. This is what we found. But we're not the ones responsible for submitting the proper paperwork. And it has, the correspondence that you sent,
Did I say you were?
no, the
Then
correspondence.
why are you pointing me and telling me that? You don't have to convince me of that.
The correspondence that was sent to this fiscal court, yes, yeah, to appeal and to litigate. And the similarities with the other issue, a lot of similarities. And that needs to be, the biggest thing is that the taxpayers are going to be at the end of this stick, regardless of the outcome.
If we win, there won't be any consequence.
Well, time will tell. There's a motion and a second. All those for Commissioner Sprague's motion?
And I don't think it throws the treasurer's office or any other employees under the bus, that vote to appeal this, but that's just my opinion.
The vote doesn't, it's his comments that do. I only heard two. Was there three? I'm sorry.
Yeah.
Three. I'm going to vote against this appeal. Motion does carry.
I would ask you to make sure that we are privy to any communication you have with the retirement board, because I don't want to hear it for the first time in court. And you told Desiree not to have any more
Do you have that
communication with the
email?
retirement board.
I don't communicate.
Gentlemen,
I'm not, hang on a
chance at
second,
winning.
Commissioner Lamb, because, listen, I don't have, you guys have to understand how this works with the state agency. Certain people, because of the nature of this information, is confidential. I don't have access to
All I ask is that
communication
any
to them.
communication y'all have,
He
that we
does.
could be privy to it.
And he
if we're
has
gonna
been
appeal it.
communicating to. The emails, his response was that he's the appointing agency. When he sends off his stuff to the state, when he makes his appointment, he has to get approval from the state. We're not involved in that. So I don't know what he's talking about. We're going to move on with item A under new business.
I move for a short
21,
recess.
22.
I'll second that.
All those in favor say aye. Aye. Any opposed? Motion carries. We'll go ahead and resume. I had Brad send you guys an email. You might want to read it in response to, actually from the sheriff, as far as they do not appoint until they get approval from KPPA. So item A, the 21-22 earthquake renewal quote. You should have a copy of it.
No, we don't. No.
It's $50,608.85.
Keiko.
With
Yeah, it's
Keiko.
Keiko. It's a limit of 20 million, deductible is 25,000, and I have no idea what TIV means on that quote. TIV, yeah. It says TIV 40,
Tax.
taxable value, I bet. $40,689.04.
I think it's 40 million.
40 million.
Yeah.
It's probably tangible inventory.
Value, that's probably right. Yeah.
Is there a motion,
So moved.
Second.
motion to accept?
Yes.
All those in favor say aye.
Aye.
Aye. Any opposed? Motion carries.
Only thing on there is transfer.
These are the three documents that Josh is going to need when he goes to get federal grant monies, or CDBG. I'll read the first one. This is the Fair Housing Resolution. Let it be known that to all persons of the city, county of Marshall, that discrimination in the sale, rental, leasing, financing of housing or land to be used for construction of housing or in the provision of brokerage service because of race, color, religion, sex, or national origin is prohibited by Title 8 of the 1968 Civil Rights Act, Federal Fair Housing Law. It is the policy of the County of Marshall to implement programs to ensure equal opportunity in housing for all persons regardless of race, color, religion, sex, or national origin. The Fair Housing Amendments Act of 1988 expanding coverage to include disabled persons and families with children, and HUD 2012 regulation expanded coverage to sexual orientation or gender identity. Therefore, the county does hereby pass the following resolution. It is resolved that within available resources, the county will assist all persons who feel they have been discriminated against because of race, color, religion, sex, sexual orientation, gender identity, national origin, disability, or familial status to seek equity under federal and state laws by filing a complaint with the U.S. Department of Housing and Urban Development, Office of Fair Housing and Equal Opportunity Compliance Division. Be it further resolved that the county shall publicize this resolution, and through the publicity shall encourage owners of real estate, developers, and builders to become aware of their respective responsibilities and rights under the federal fair housing law and amendments and any applicable state or local laws or ordinances. Said program will at a minimum include 1, printing and publicizing of the policy and other applicable fair housing information through local media and community contacts. 2, distribution of posters, flyers, and any other means that will bring attention of those affected, the knowledge of their respective responsibilities and rights concerning equal opportunity in housing. And 3, prepare and analyze of impediments to fair housing choice and actions to mitigate such impediments. Is there a motion to approve this resolution?
So moved.
Second.
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries. Instructions
For compliance with Civil Rights Title VI, the Department for Local Government has and will continue to take a proactive approach to fully implement procedures to eliminate discrimination on the basis of race, color, or national origin. In accordance with KRS 344-015, DLG developed the Title VI implementation plan. All organizations that receive pass-through federal funding from DLG must comply with this implementation plan. To ensure that DLG meets its compliance responsibility, procedures have been established to provide monitoring of Title VI compliance activities and complaint processing in all programs. To meet the requirements of compliance, your organization has two options. Your organization can adopt a plan created by DLG. To ensure full compliance with DLG's implementation plan, the following items must be retained by the grantee with your completed Civil Rights Title VI self-survey, non-discrimination policy, compliance assurance, including a copy of all contracts used to provide direct services to client, and a copy of all contracts used to assure that subcontractor or vendors are clearly aware of your agency's commitment to Title VI. Note, please ensure that a local Title VI coordinator is identified in question 5 of the self-survey. In addition to the self-survey, your agency must complete the enclosed statement of assurance. Full compliance cannot be achieved unless all of these items are included. Though most organizations have chosen to adopt the DLG plan, your organization may create its own Title VI implementation plan and submit it to DLG for approval. Regardless of which option your organization chooses, you must maintain a copy of Title VI documents for review by the general public and DLG HUD or its representatives. If you have questions about Title VI or completing the required documentation, you may contact DLG. And then this is just the self-survey. Is there a motion?
So moved.
Second.
All those in favor say aye.
Aye.
Aye. Any opposed? Motion carries. This is Title VI Statement of Assurance. Let's see. Fair Housing Procurement Code. KCDBG Procurement Code, all procurements made by Marshall County, hereinafter referred to as the grantee subrecipient, involving the expenditure of local, state, federal funds on the CDBG project, DRA Southwest 1, shall be made in accordance with the following procurement standards. Procurement transactions, regardless of method or dollar value, will maximize open and free competition. The grantee subrecipient shall not engage in procurement practices that may be considered restrictive in trade. Purchases will be reviewed by the treasurer to prevent duplication and to ensure that costs are reasonable. Methods for procurement. Procurement shall be made by one of the following methods: small purchase procedures, competitive sealed bids, competitive negotiation, non-competitive negotiation. Small purchases. For purchases of less than $50, efforts will be made to get the lowest and best price, but written records of such efforts are not necessary. Purchases that cost more than $50 but less than $20,000 require quotations of rate, price, etc., but no legal advertisement is required.
Can I stop you? Can I stop you right there? Should that be 30
That's what I was just going to say.
now,
Yeah.
based on the new law?
Let's see.
I assume that's what that's meant to do, is match
And this is for federal dollars.
procurement.
Well, we'll go ahead and say purchases that cost more than $50 but less than $20,000 require quotations of rate.
I bet that
Where's
was
$50 come in?
I think that's just something they identify as a small purchase. So anything under 50, it doesn't have to be a,
Well,
Yeah.
anything under, I see what you're saying.
Yeah.
Like ours is 300. I
Right,
think.
so they
Yeah.
don't require anything
So-
under 50.
I guess it would just be a question of, does that need to match? Because we
So,
don't want to,
state-
hamstring.
Yeah, we can make sure if that's the case. I'll have him check. He may have copied this off.
Yep,
From
before that.
previous, but we'll make a note. For federal dollars.
I mean, the grant may have something that is different than what KRS is too, so we need to make sure that.
Sure. The CDBG may have a different set of guidelines for procurement, which if.
We can
if
have
it's
them
less-
define this part.
Yeah, but I mean, if it's less than 30, I think you're fine. I don't think you want to go above 30 because then you're
No.
against state, you know
No,
what I mean?
I agree. I
Yeah.
just think those between 20 and 30 could be affected if, you know what I'm saying?
Sure, yeah.
So the more that you can, to me,
Well, purchases that cost more than 50, but less than 20,000 require quotations of rate, price, etc., but no legal advertisement is required. So they're saying legal advertisement above 20 is required.
That may be something that's required by the grant. We might not be able to change it.
Which,
Or they could just be old numbers.
They could be old numbers.
It- yeah, we'll confirm and make sure that if that does require, if that is citing the 30,000, because it is procurement, we'll change that. We'll just make sure that in the motion we cite that. The grantee subrecipient will solicit responses from all at least 3 vendors. If written responses are not available, a statement explaining the procurement will be prepared and filed. If quotations are obtained via telephone, a memorandum will be prepared setting forth the date the calls were made, parties contacted, and prices obtained. The grantee subrecipient will make the award to the lowest responsive and responsible source and enter into a contract formalizing the scope of the work in terms of compensation. B, competitive sealed bids. Bidding will be employed when detailed specifications for the goods or services to be procured can be prepared, and the primary basis for award is cost. When the cost of a contract, lease, or other agreement for materials, supplies, equipment, or contractual services other than those personnel or professional exceeds 20,000, an invitation for bids, IFB notice will generally be prepared per KRS 424-120. This notice will be published at least once in qualifying official newspaper. A general circulation within the community, this newspaper notice will appear no less than 7 days and not more than 21 days before the due date for bid proposals. In addition, the grantee subrecipient must solicit sealed bids from responsible prospective suppliers by distributing a copy of such notice to them. The IFB will include a general description of the goods or services to be procured, the bid deposit and bond performance required if applicable, the location where bids, forms, and specifications may be secured, the time and place for opening bids, and whether the bid award will be made on the basis of the lowest bid price or the lowest evaluated price. If the lowest evaluated price is used, the measurable criteria to be utilized must be stated in the IFB. The newspaper notice must also contain language that calls to the attention of bidders and applicable requirements that must be compiled with, such as Section 3 of the 1968 Housing Act, Section 109 of the 74 Housing and Community Development Act, Civil Rights Act of 64, Executive Order 11246, and the Davis-Bacon Act. Sealed bids will be opened in public at the time and place stated in the IFB. The grantee subrecipient will tabulate the bids at the time of bid opening. The results of the tabulation and the bid documents will be evaluated by the review committee, which will make recommendations to the grantee subrecipient. The grantee subrecipient will make a firm fixed price contract award in writing to the lowest responsive and responsible bidder after the grantee subrecipient makes the bid award. Contract will be prepared for execution by the successful bidder. After the contract is signed, all bid deposits will be returned to all unsuccessful bidders. The grantee subrecipient may cancel an invitation for bid or reject all bids if it is determined in writing that such is in the best interest of the grantee subrecipient. The grantee subrecipient may allow a vendor to withdraw a bid if requested at any time prior to the bid opening. Bids received after the time set for bid opening shall be returned to the vendor unopened. Bid overages, the following options are available for awarding a bid following an overage. 1, obtaining additional funds from another source and continuing with the original IFB. 2, rejecting all bids, revising project scope and bid specifications, and issuing a revised IFB competitive sealed bid open to the entire public. Or 3, conducting competitive negotiations with all bidders. Grantees must seek pre-approval from DLG for this option. Competitive negotiations under option 3 must take place under the following criteria. If discussions pertaining to the revision of the specifications or quantities are held with any bidder, all of the bidders shall be afforded an opportunity to take part in such discussions. 2, after discussions with the bidders, the grantee shall revise the scope of work accordingly and issue an RFP open to all bidders. Providing for expedited proposals, no advertisement is required, but the grantee shall allow at least 7 days for bidders to submit proposals. 3, the RFP shall be awarded on the basis of lowest bid price. C, competitive negotiation. The grantee subrecipient may utilize competitive negotiations regardless of contract amount upon a written determination that 1, specifications cannot be made specific enough to permit the award of a bid on the basis of either the lowest bid price or the lowest evaluated bid price. In other words, bidding is not feasible. 2, the services to be procured are professional or personal in nature. The use of the competitive negotiation procurement method for contracts other than architectural, engineering, planning, or administrative services must be pre-authorized by DLG with the expectation of procurement of certain professional services, principally engineering services. Competitive negotiations will proceed as follows. 1, proposals will be solicited through a qualifying official newspaper advertisement. Additionally, a request for proposal, RFP, may be prepared and mailed to the qualified vendors. The newspaper advertisement must be published at least 7 days and not more than 21 days before the date for receipt of the proposals. The RFP will describe services needed and identify the factors to be considered in the evaluation of proposals and the relative weights assigned to each selection factor. The RFP will also state where further details regarding the RFP may be obtained. The RFP will call attention to the same regulations discussed in the bidding process. Requests for proposals will always include cost of a selection factor except for engineering services. 2, award must be made to the offeror whose proposal is determined by the review committee to be most advantageous to the program, with price and other factors considered. Evaluations must be based on the factors set forth in the request for proposal and a written evaluation of each response prepared. The review committee may contact the firms regarding their proposals for the purpose of clarification and record in writing the nature of the clarification. If it is determined that no acceptable proposal has been submitted, all proposals may be rejected. New proposal may be solicited on the same or reversed terms, or the procurement may be abandoned. For the procurement of agricultural engineering, AE, professional services, an alternative to RFPs may be used. The grantee subrecipient may publish a request for qualifications. RFQs are handled in a similar method to RFPs, with the exception that cost is not a factor in the initial evaluation. The review committee will evaluate the responses and rank them by comparative qualifications. The highest scoring person or firm will be contacted, and the selection committee will negotiate cost. If the committee is unable to negotiate a satisfactory cost arrangement, the second highest scoring person or firm be invited to negotiate. The committee will maintain a written record of all such negotiations. D, non-competitive negotiations. Non-competitive negotiation is procurement through solicitation of a proposal for one source, and if often referred to as sole source procurement. A contract may be awarded by non-competitive negotiation only when the award is feasible under small purchase procedures, competitive sealed bids, or competitive negotiations, and one of the following circumstances applies. There is some public emergency that will not permit delay resulting from competitive solicitation. The grantee must declare an emergency as authorized by law, or 2, the results of the competitive negotiations are inadequate, or 3, the product or service is available only from a single source. Caution: the use of the non-competitive negotiation procurement method must be authorized by DLG. The following requirements apply to the non-competitive negotiation procurement process. 1, negotiations must be conducted with the selected company regarding the scope of work and price. And 2, preparation and signing of a contract formalizing a scope of work and the terms of compensation is required. And 2, contracts. Generally, all procurement in excess of 500 will be memorialized and supported by a written contract. Where it is infeasible or impractical to prepare a contract, a written finding to this effect will be prepared, and a purchase order regarding the transactions will also be prepared. The contractual provisions required by the common rule will be included in all contracts and purchase orders. 3, documentation. All source documentations or documents supporting any given transaction, receipts, purchases, orders, invoices, RFP, RFQ data, and bid materials will be retained and filed in an appropriate manner. Where feasible, source documents pertinent to each individual procurement shall be separately filed and maintained. Where it is infeasible to maintain individual procurement files, source documents will be filed and maintained in a reasonable manner. Examples include chronologically, by vendor, by type of procurement, etc. Whatever form of documentation and filing is employed, the purpose of this section is to ensure that a clear and consistent audit trail is established. At a minimum, source document data must be sufficient to establish the basis for selection, basis for cost, including the issue of reasonableness of cost, and basis for payment. 4, locally owned, minority owned, female owned, and small businesses. The grantee subrecipients shall make and document efforts to solicit participation of locally owned, minority owned, female owned, and small businesses where feasibly. Evaluation criteria will include a factor with an appropriate weight for these firms. A list of locally owned, minority owned, female owned, and small businesses, and also minority businesses located within the trade region shall be maintained and utilized when issuing IFBs, RFPs, and RFQs. The grantee's subrecipient shall also consult this list when making small purchases. 6, Section 3. Grantee subrecipient shall abide by its Section 3 action plan and shall, to the maximum extent feasible, as required by 24 CFR Part 135, award contracts to businesses that provide economic opportunities for low and very low income persons residing in the project area. Code of Conduct. 7. Item A, conflicts of interest. In addition to the prohibitions set forth in 24 CFR 540-489H and 24 CFR 8536B and 3, the following prohibitions shall apply. It shall be a breach of ethical standards for any employee with procurement authority to participate directly in any proceeding or application, request for ruling or other determination, claim or controversy, or other particular matter pertaining to any contract or subcontract, and any solicitation or proposal therefore, in which, to his knowledge, A, he or any member of his immediate family has a financial interest therein, or B, a business or organization in which he or any member of his immediate family has a financial interest as an officer, director, trustee, partner, or employee, is a party, or C, any other person, business, or organization with whom he or any member of his immediate family is negotiating or has an argument or arrangement concerning prospective employment is a party. Direct or indirect participation shall include, but not be limited to, involvement through decision, approval, disapproval, recommendation, preparation of any part of a purchase request, influencing the content of any specification or purchase standard, rendering of advice, investigation, auditing, or in any other advisory capacity. Number 2, it shall be a breach of ethical standards for any person to offer, give, or agree to give any employee or former employee, or for any employee or former employee to solicit, demand, accept, or agree to accept from another person a gratuity or an offer of employment in connection with any decision, approval, disapproval, recommendation, preparation of any part of a purchase request, influencing the content of any specification or purchase standard, rendering of advice, investigation, auditing, or in any other advisory capacity in any proceeding or application, request for ruling or other determination, claim or controversy or other particular matter pertaining to any contract or subcontract and any solicitation or proposal therefore. 3, it is a breach of ethical standards for any payment, gratuity, or offer of employment to be made by or on behalf of a subcontractor under a contract to the prime contractor or higher tier subcontractor or any person associated therewith as an inducement for the award of a contract or order. 4, the prohibition against conflicts of interest and gratuities and kickbacks shall be conspicuously set forth in every local public agency with written contract and solicitation therefore. 5, it shall be a breach of ethical standards for any public employee or former employee knowingly to use confidential information for his actual or anticipated personal gain or the actual or anticipated personal gain of any other person. B, penalties, any elected official, employee, or designated agent of the grantee's subrecipient who knowingly and deliberately violates the provisions of this code will be open to civil suit without the legal protection of the grantee's subrecipient. Furthermore, such a violation of these procurement standards is grounds for dismissal by the grantee's subrecipient. Any contractor or potential contractor who knowingly and deliberately violates the provisions of these procurement standards will be barred from future transactions with the grantee subrecipient. So if we do a motion, just include upon confirmation of the $20,000 limit to $30,000. It says $20,000 for the updated. We'll still confirm it.
Yeah.
It ain't gonna hurt.
I move we accept, and pending clarification of the limit of 20,000 to 30,000.
Is there a second?
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. Transfers.
Erica had to step out, so I'll do the transfer. From the occupational tax to general fund, $348,178. From occupational tax to road fund, $350,000. Occupational tax to the sheriff fund via general fund, $300,926, and for a total of $999,104. That's all budgeted. And then also a transfer to the transient tax, $40,212.56.
Move we approve the transfer.
Second.
All those in favor say aye.
Aye.
Aye. Any opposed? Motion carries. Bills and claims, is there any reason to deny payment of the bills and claims? Hearing none, let the clerk record the bills and claims are to be paid. Do we have a motion to adjourn?
So moved.
Before we do, I'm sorry.
Yeah.
We need to schedule a special, we're going to be meeting on the 9th, June 9th. Can we schedule a special call meeting before the budget workshop? We're meeting at 9 a.m., so 8:45.
Oh, okay.
Is that fine?
Yeah.
We've got a budget amendment, we got to do the first reading, and we can't have the budget and the budget amendment ordinance at the same time. So if we can schedule a special call meeting before the budget workshop on June 9th at 8:45 for the first reading of the budget ordinance.
That's just going to be a first reading, right?
Be the first reading.
I'll have court.
Yeah, we're just going to read it. Yeah.
Before we adjourn, have we received our ARPA money yet?
No.
Have we?
No, the monies are available. We're not going, it's kind of like the CARES monies. We're going to wait till July 1 so
Okay.
that we receive those dollars in the next fiscal year. Instead of receiving them now, accounting for them in this fiscal year, and then rolling them into the next fiscal year. We already have a federal, we meet the audit standards to have a single audit, and those monies can be used to pay for that, so it doesn't matter. It's more an administrative decision. First and a second to adjourn. Did I hear that?
If you didn't,
Yeah, so moved.
All those in favor say aye. Aye. Any opposed? Motion carries.